Okay, good morning. Let's go ahead and get started. Looks like we're going to have a late arriving crowd today, and that's fine. This week, we're going to talk about intellectual property law. And so what that involves is things like trademarks, copyrights, patents, things that the law protects from use by unauthorized people. It protects the rights of the authors, designers, inventors, the people who come up with, not ideas, but with designs, words, processes, music, artwork, the things that are original that deserve protection. And so we're going to, again, just look at those. Really, intellectual property is a pretty broad subject, but the ones we're looking at today are trademarks, copyrights, and patents. So let's talk about a trademark first. What is a trademark? Trademark is a distinctive word, could be a symbol, could be a sound, could be a design that identifies the manufacturer as a source of goods or as a certain business. Identifies a certain business for whatever business it does. So an example of a trademark would be the Target symbol, the red circle with the red circle around it. That's a Target trademark. We see that, and everybody knows, most everybody knows that that represents Target. You can trademark slogans. So just do it. That's a Nike trademark slogan. Finger licking good. That'd be a Kentucky Fried Chicken trademark slogan. A lot of businesses not only trademark their symbol, but they trademark their name as well. So Target, as the name of a business, would be trademarked. Almost all businesses do that as well. So what kind of protection do we afford trademarks? So trademarks can be registered with the U.S. Patent and Trademark Office, and that gives you that gives the maker or creator of the trademark something solid that they can use if somebody comes and tries to use their trademark in an unauthorized way. If it's registered, then the trademark creator can then go and say, well, as of this date that it was registered, it's mine. It gives you something solid to use as proof in court. But you don't have to register a trademark. Target could have used their little circle symbol and never registered it, but it still acquires protection under the law so long as if it's widely known to be a symbol of Target. So even though you don't have to register a trademark to have it protected, it's a good idea to do so because, again, if you get into a dispute and you have actually registered your trademark with the U.S. Patent and Trademark Office, then you've got some solid proof as to when you've done so, and it makes it easier for you to protect your trademark. You'd much rather have a piece of paper that shows that the trademark belongs to you than having to go to court and argue that it belongs to you and having a more uncertain outcome. So that is trademark registration. So what kind of misuse of trademarks do we get into? The two ways we're going to talk about today are trademark infringement and trademark dilution. And they can be a little bit confusing when you try to distinguish between the two because they have a lot of overlap. And I'm not so much worried for our purposes of this class that you drill yourself on being able to distinguish between trademark dilution or trademark infringement. The idea is the same behind them, but we're going to take them separately anyway. Trademark infringement is when a trademark is copied to a substantial degree or used in its entirety by another. Counterfeit goods. That'd be trademark infringement. When we go to New York and we stop by those tables on the sidewalk where they're selling fake, whatever it is they're selling, those aren't real Louis Vuitton purses. but they look like them, and so that would be an example of trademark infringement. Somebody's just copied a trademark and they're using it in a way that's not authorized. It doesn't have to be exact for it to be infringement. It could be substantially similar enough such that it would cause confusion in the mind of a consumer. So not much confusion, obviously, if we're copying it, right? I mean, if we're copying it, it's meant to look exactly like the real trademark. But it could result in confusion if we're trying to be cute and somebody has designed a counterfeit good and they think maybe their defense is going to be that they didn't use the name exactly as it had been used or the image exactly as it had been used. I'll give you an example in a minute. There was a South Korean fast food chicken restaurant, and it was named it was 3 words, Louis Vuitton Dak. And Ton Dak in Korean means whole chicken. And so this South Korean fast food restaurant called themselves Louis Vuitton Dak, and their little paper trays that they serve their chicken in and their packaging, it looked a lot like the Louis Vuitton logo. The background looked similar, and it was clearly designed with Louis Vuitton in mind. So Louis Vuitton sued them and won. And so the owner of the South Korean fast food chain, I guess, thought he was going to be cute or had some spite or whatever. And so he changed his name to 2 words. Louis V, that was all one word, and then Ton Dak, the second word. So instead of reading 3 words Louis Vuitton Dak, it was 2 words Louis Vuitton Dak. And then he ditched the packaging that mimicked Louis Vuitton's logo, and he got sued again and got found guilty again of violating trademark laws. So you have to be really careful in how you do that. So trademark infringement, that's really copying a trademark, trying to pass it off as the real thing. Trademark dilution is when you're not necessarily trying to pass off a trademark as the original, and you may not be trying to confuse consumers to believe that it was manufactured by the person you're copying from, but you're trying to piggyback on the brand, or you're trying to get some good association between what you're doing and the brand. So, for example, I could manufacture harmonicas and call it Ferrari harmonicas, and I might get sued by Ferrari for trademark dilution. I wouldn't be liable for infringement because I haven't, let's assume for this example, I didn't copy the Ferrari lettering, their font, their design. I'm just using the word Ferrari. And so there's no confusion that the harmonica is the same as a Ferrari sports car. But it might cause the consumer to associate whatever good feelings or bad feelings, depending on the mindset of the consumer, of my harmonica with the Ferrari car. And so that's this idea of dilution. We don't want our trademarks and our slogans and that kind of thing to be used in other ways that water down our brand. Water down is another word for dilution. So in my example about Louis Vuitton Dak, I think that you could have an argument for trademark infringement and trademark dilution. The infringement would have been the use of the word Louis Vuitton in the title of the fast food chain. That's just copying it, right? I mean, that's trying to pass it off as the same name. But the dilution could have been in that no one really thinks that Louis Vuitton, the fashion giant, is serving fast food fried chicken in South Korea. The logo that the fast food restaurant chain was using, although it was made to look in the design and feel like Louis Vuitton, it wasn't a direct copy. They didn't use the L and the V. They used some other letters that didn't make sense to me, but I don't speak Korean or read Korean, so who knows? But that would be an example, I think, of trademark infringement and trademark dilution. So the differences are that really in infringement, you're copying the trademark and you're trying to cause confusion in the mind of the consumer as to whether the original manufacturer or seller or business is the same as what you're trying to pass off. Dilution just means we're not trying to confuse the consumer necessarily. We're just trying to kind of piggyback, so to speak, on this brand, and we're going to water down the name or the reputation of the brand by using it in different ways than the original, if that makes sense. So in order to state a case for either trademark dilution or infringement, you've got to first be able to show that you have a trademark. If it's registered, then you're good to go on showing you have a trademark. It's been recognized by the government. Mr. Fields.
Is the outline for this book?
It is not. And I just realized that. The outline is not up, and that's my fault. So I meant to bring my laptop home last night. It's a long story. I did not bring my laptop home last night, and so I didn't post it. So I apologize for that. My bad. So we're talking about stating a claim for dilution or infringement. So you've got to actually have one. Well, if you don't have it registered, then you would have to prove to the court that your mark is famous or it's widely recognized. There's not, as you could guess, going to be a definition of the law of what exactly makes something famous or what exactly makes something widely known. And so a lot of these decisions, if not all these decisions, when you get into disputes, they're really a case-by-case basis. There's really no way to make or write a law with language that is going to tell you how to define what is and isn't famous or what is and isn't widely used. And so if you have not registered your trademark and you're dependent on the jury or the judge to decide whether or not your trademark is famous or widely recognized, then that's a lot more difficult than if you'd just gotten your registration. So that's one element. And then you've got to show the court that there is a likelihood that your brand has been tarnished or weakened or diluted. You don't have to show that there was actual confusion. You just have to be able to show that there was a likelihood of somebody believing that this infringed trademark was real or that this diluted trademark was intended, or maybe not intended, but was going to cause some sort of confusion. That was a long way of saying it. So when we're talking about, again, the difference between infringement and dilution, I'll give you some ways that trademarks can be diluted, and hopefully that'll be a better illustration of the difference between just infringement and dilution. One is blurring. And this is where the person who's doing the trademark dilution wants the consumer to start to associate their product with the real thing. So if I made toothpaste and called it Google toothpaste, or in my harmonica manufacturing that I've named Ferrari harmonicas, I want the consumer to maybe not necessarily think that Google's making toothpaste, but I might want my product associated with Google, the Google name, or associated with the Ferrari name, such that whatever goodwill they enjoy in the marketplace, that somehow that'll get projected onto mine. That's kind of blurring. Tarnishment is if the trademark is being used in a way that is offensive or unflattering. So one of the sportswear sneaker companies like Adidas, if I made a product that was that ran counter to what Adidas does, something really unhealthy, like, cookies with 50 grams of fat in each one, and I named them Adidas Fat Cookies. That would be a way, that would obviously not be, I'm not trying to piggyback on the goodwill of Adidas, but that would be a way that would tarnish the Adidas trademark because it's counter to what they stand for. And then another way is just the free ride, and that's sort of what I was talking about before with wanting good names. So if I named, if I had opened a high-end restaurant and I named it Gucci, then I do want my customers to associate the idea of the name Gucci at my high-end restaurant with the idea of high-end fashion or something like that. So again, I'm not infringing on the trademark with the fact that I'm putting that on a restaurant, because Gucci clearly is not in the food business. So I'm diluting it in that way. I could also be infringing because I'm directly copying their name. So you see how there can be some overlap between both of these ideas of infringement and dilution. When we talk about the distinctiveness of the trademark, then the courts are looking for things that are easily associated with that brand or with that business. That we can look at or hear the name or hear the slogan and we immediately know what that means. But there are different strengths, I would say, of a trademark. There are more unique trademarks than others. And so in general, the more unique, the more a trademark is a word that doesn't mean anything else, the more a trademark is invented just for that purpose. And I'm going to give you some examples in a minute. But the more that those things are, the more protection it acquires under the law. So it's kind of a sliding scale. The more unique, the more descriptive, the more that trademark applies just to you, the more protection it's going to get. On the other end of the spectrum, the more general it is, the more that it's just descriptive, the less protection it's going to get. And that's because, again, we don't want to give trademarks to words that we use every day. I mean, I can't trademark the word pen. I can't trademark common everyday things or common everyday descriptive things. It has to be associated with a business product, manufacturing process, so on and so forth. So let's think about that for a second. Let's start at the top of the pyramid of trademarks that enjoy the most protection. Have y'all studied this in marketing any? Talked about different kinds of trademarks or anything like that? A little bit? All right, so have you heard, so the first block of my pyramid at the top would be fanciful trademarks. And these are words that don't have any meaning other than the name of the product or the name of the business. They're not a word in any language. They don't have independent meaning. They don't describe the goods and services. So examples of fanciful trademarks would be Exxon. That's not a word. That does not describe gas. It's a made-up word that we associate with the gas company Exxon. Google. Google invented the name Google. Of course, it's now a verb, I think, in the dictionary, so it might have independent meaning. But Google would be one. Google means one thing and one thing only. Rolex is another example of that. Rolex is not a word in the English language or any other language. It's invented, and now we know that a Rolex is a watch made by Rolex. So what are some other, y'all tell me, what are some other fanciful trademarks that come to mind? What other words do businesses have as trademarks that don't have any meaning anywhere else?
Chick-fil-A.
Say louder.
Chick-fil-A.
Chick-fil-A? Yeah, I mean, that's not a word in anything, right? It's a mashup of the idea of chicken fillet. Yep, Chick-fil-A, I would say, is fanciful. Come on.
Dick's.
Say that again.
Dick's.
Dick's Sporting Goods?
Never mind, sporting goods,
Yeah, they wouldn't trademark, sporting goods alone wouldn't be able to be trademarked, but you might trademark the name, you could certainly trademark the name Dick's Sporting Goods, okay? But I don't think that'd be fanciful because that word does have other meanings in the language. So it's not exclusive just to Dick's Sporting Goods. Come on. Fanciful trademarks. Kia. I don't think Kia is a South Korean company though, right? Or so I don't know if that has any meaning, but I think Kia is probably one as well. Tesla, yeah, that's a made-up word. That's a good one. That'd be an example of a fanciful trademark. So those are the ones that get the most protection, and that makes sense because it wasn't like, I'm trying to trademark Tom's Sporting Goods. That's not original. But if I've taken the time to make up a name for my company like Tesla, or Kia, or Rolex, then of course we want to give that. You can understand why that would have more protection under the law. The next step down in our hierarchy of trademark levels that enjoy the most protection would be arbitrary trademarks. And those would be a word that does have a common meaning, but it's not related to the goods or services. So that now we've associated that word with that good or service, even though the word by itself doesn't suggest it. So an example of that would be Dove soap. The word Dove is a word independently, has nothing to do with soap, but we associate, you can picture in your head the little Dove trademark and the word Dove itself. Apple. Apple sure doesn't mean a computer in everyday terms, right? But we all know what an apple is. I can see an apple on Mr. Pachame's laptop right now, and I know exactly what that is. Target. The actual word Target has nothing to do with a store like that, but we certainly associate that. Delta, that's a word independently, but has nothing to do with an airline. So y'all help me come up with some other arbitrary trademarks. Amazon, good one. Starbucks has nothing to do with coffee, right? That's kind of a made-up name, though. That could be fanciful. Because I guess star and bucks independently would be words, but so either one, you'd have a lot of protection for Starbucks. What else? Arbitrary trademarks.
Interschool.
Who was it?
Interschool.
Who is that?
Musical.
Showing how unhip I am. I have no idea what that is. Who was it, Dalton? Square. All right, that really doesn't suggest payments, right? Okay, good. So those get protection as well. There are also, on our next level down would be suggestive trademarks. And these are words that have independent meaning, but they do have some sort of relation to the product or service. They're suggestive of it, even if they're not directly descriptive of it. So something like Netflix or Airbus, the plane manufacturer. Those at least suggest some of what the product is. And you can see we're going down, we're getting less protection as we go. And the reason is now we're getting into more common words. And so the way that we combine them can sometimes result in some trademark protection. But generally, the more generic, the more common the name, the less unique it is, the less protection it gets. Anybody think of any more suggestive trademarks? Microsoft. What do y'all think? Soft comes from software, right? And micro is a computer-related word, so I think that would fit.
I would say Blockbuster, like you're talking about movie, like how that was a Blockbuster.
Blockbuster would be good because that does bring to mind big-time movies, right? Blockbuster is a good one. So then as we keep going down our little pyramid, We started at the top with fanciful, then we went to arbitrary, then we went to suggestive. Now we're getting to descriptive marks. And these are ones that aren't just suggestive of the product, they're right out descriptive of it. And they're going to get less protection because now we're getting into really sort of adjectives. You couldn't trademark, for example, you couldn't trademark cold and creamy for ice cream if that was a description. I mean, ice cream is cold and creamy. You couldn't trademark, so here's some examples of that. Holiday Inn. That's a descriptive mark. It does enjoy protection because it's become so widespread over time that we know when we hear Holiday Inn that is a hotel chain. Sharp as the maker of TVs. That's a straight up descriptive word that does relate to the product. But over time, that's become associated with that product. So that could enjoy some trademark protection. I hope you'll also see that as we go down the pyramid, so to speak, not only would you get less protection in your trademark for infringement, for having yours copied, but you'd get less protection from it being diluted or watered down. Because let's say that I started a knife company and I wanted the name Sharp in my knife company. Well, it's going to be hard for the Sharp television people to argue that my Sharp knives are diluting their trademark because Sharp is a descriptive general word. We would expect that Sharp could be used to describe other things. It seems more fair that general words would be fair game for people to use. Now, if I was trying to make another TV and I named it Sharp, or if I was making a laptop or something having to do with, audio visual technical equipment, I might infringe upon a trademark or dilute it if I use Sharp. But if I'm making something completely unrelated, then it might be harder for them to have a case against me. Whereas if we're at the top of the pyramid, there's nothing else that I could really make and put Google on it or Exxon on it that we would deem to be a fair use of those words because, again, they're not even words themselves, and they really were only invented for one thing. So as we go down, the more general we get, the less protection you get. The very bottom of our pyramid would be just generic names like clock, donut, coffee. You can't trademark things like that. Those words they're not associated in a distinctive way in the marketplace with a certain product or company. Okay, moving on from trademarks, let's talk about, this is a subset of trademarks, but there is something called trade dress. And it might not be a word or a slogan or an image, but it might be the overall image or appearance of a product. So think like packaging, the Coke glass bottle, the way it's fluted, that can't be copied. That's known as trade dress. The blue box from Tiffany, blue in and of itself is not, you can't trademark the color blue. But that blue box, when you see that robin's egg blue box, we've come to associate that with Tiffany. You can't trademark or a box either, because you just can't do that. But that blue box with the white ribbon, that could be considered trade dress, and that might enjoy protection. Both in infringement, if it was copied, or in dilution, if it were used in a different way by maybe somebody who manufactures toys, not related to jewelry, but again, might dilute the brand. Even something like the interior design of a restaurant or the store So like think about the way McDonald's looks when you go in there, or Dunkin' Donuts looks when you go in there. It might not be a particular image necessarily, but if you're designing and building out your store with the same color scheme, the same physical setup, using the same fonts for your wording, to where if you walk in, somebody would look around and say, well, this is meant to copy Dunkin' Donuts. So those are trade dress, and it can absolutely be infringed or diluted. Something I mentioned earlier that hopefully is apparent to you now is that in any of these disputes in intellectual property, it's always a case-by-case basis. It just depends on what exactly the trademark is, what exactly the trademark is we're talking about. There's no way to make a definition of what would constitute a violation of that. But we could look at a picture of an interior of a donut restaurant that was supposed to mimic Dunkin' Donuts, and then we could look at the interior of a real Dunkin' Donuts, and we could look at those and decide if you were on a jury. And you could compare that in your head. You might see a real Tiffany blue box, and then you might see a knockoff Tiffany blue box that has a white corner on it or a white edge, and if you were on the jury, would have to decide, is that sufficiently similar enough? Is that enough to cause a likelihood of confusion? So those are the things that you would think about. So what follows from the fact that these are fact-intensive cases when you have disputes and that they're unique is that they're also very costly. When we have areas of the law where we know what the definition of a violation is or definition of what a crime is in the law, then when the sides are preparing in a court case, we have a lot better idea of what to expect, because we could look at cases who had similar fact patterns. We could look at previous outcomes. We would have something sort of concrete to compare our case against. But with trademarks and patents and copyrights, the rest of what we're going to talk about today, it's costly because you're talking about something unique every time. If it wasn't unique, then it wouldn't be trademarked, copyrighted, or patented. So it's always going to be a case-by-case thing. All right, let's talk about patents for a second. Patents, we associate, I think what first comes to mind generally when we're talking about patents is inventions. And inventions are certainly patentable. But broadly, the idea of what is patentable is not just an invention, but a discovery, a process, a design. These things that somebody has come up with on their own that were new, that they alone invented or designed or came up with, and that they deserve protection from. Because our society and the laws reflect that if somebody invents something or comes up with this process or design, then they should be the ones to profit off of it. That other people should not be able to copy that and profit off of their idea or design or manufacturing process. So a patent gives the inventor the exclusive use of that, whatever it is that they've patented. No one else can use it without the permission of the person who holds the patent. The person who holds the patent could sell it, they could license it, they could give other people permission to use it for certain fees or royalties, or whatever the case may be. Whoever holds the patent can do what they want with it, but somebody can't use it without the permission of the patent holder. Unlike trademarks, which don't have to be registered, a patent has to be registered. You have to register your patent with the Patent and Trademark Office in order for it to get protection. You do so. I've never done this. I've not ever been involved in any sort of patent law or anything, but there are law firms that specialize in patents. There are lawyers that do nothing but patent law, and they help you apply for your patent. They have experience, I guess, in knowing what it is that the patent office is looking for. But the patents are reviewed by lawyers at the patent office to make sure that they meet the criteria of what makes something patentable. So what does that mean? What do you have to have in order to get a patent on something? It has to be genuine. Can it be patented? Is it unique? Is this something that that you came up with? Is it novel? Meaning it has to be new and not previously disclosed. So you can't patent something that already exists, even if it's not patented. If somebody else invented it or came up with it, or it's just widely known and used, you can't go and get a patent on that. It has to be yours. It has to be new, and it has to be not previously disclosed. So if I came up with a formula for a soft drink and I put it out there, and I published my formula, I made soft drinks according to that formula for a couple of years, and then all of a sudden later on I decided that I wanted to patent it. Well, yeah, it is genuine. It was mine. It didn't exist before I invented it, but it was previously disclosed. I've already let it out into the world without getting protection for it. So generally the law will say, if it's been out, if it's been disclosed, distributed, disseminated in whatever way for a year before you apply, then it's too late. So whatever disclosure, dissemination, whatever that is, as long as it happened within a year of you applying for the patent, you should be okay. It has to be useful, has to be genuine, has to be novel, and then the third thing is it has to be useful. So it has to operate to perform its intended purpose in the real world. So the patent office is not going to give you a patent on your idea of a laser that zaps space aliens on planets 400 light years away. I mean, you can't actually prove that that works anyway, but you can't patent that idea because it's not actually useful. There's nothing you could do with that patent that would make it usable. So they're not going to waste their time on abstract or future or, ideas that aren't concrete. They've got to be useful. And then the final requirement is it has to be not obvious in light of current technology. So an example of this is that Amazon tried to get a patent on their one-click payment option, and the patent office rejected that, and they said that's just obvious. That's something that would be common to web commerce, to e-commerce these days. So they did not allow them to patent that. That was something that would be obvious in light of current technology. You can hopefully in your mind, if you think about intellectual property over time, there would have been a time when, before we had recordings, that the only thing that would be patentable or that you get a trademark on or copyright would be things that are written or images or things you can see, tangible things. But as society evolved, and as with everything, as technology evolved, intellectual property is a booming area because now we're patenting and copywriting and trademarking things on the web that aren't tangible necessarily, but that certainly exist. And things like, patenting things like computer code or the designs of video games. Those are things that the intellectual property law did not even begin to comprehend when it began. Another thing that, if you think about this, you might imagine too, is that the law is always behind innovation. in technology because we can't make laws fast enough to keep up with the new things coming out. And so that can cause problems for some people who invent or design or make things that they want to acquire protection for. Doesn't mean it can't happen. It just means that if you are in this area where you have come up with something that you believe needs protection, you really need to be careful about how you go about that. There are laws that protect you, but sometimes you might be on the leading edge of an area where the law hadn't gotten there yet. There are things that you can't patent, and that would be the flip side of what we've just described, the requirements of being genuine, novel, useful, and not obvious. So if we take the opposite of that, we would think of things that aren't patentable, things that aren't genuine, ingenuine things, novel, things that aren't new, useful, things that are not useful or practical or can be actually manufactured and carried out, and the requirement of being not obvious, the flip side of that would be obvious. So you can't trademark things like the laws of nature. Trademark patent. You can't patent natural phenomena. You can't patent abstract ideas. Those things are just not, they don't acquire protection under the patent law. So, patent infringement. That's when somebody uses your patent or whatever it is that's protected by your patent, they use it for their own commercial gain. It could be in whole or in part. It doesn't have to be exact. That's patent infringement. Some examples of that are that Nintendo had to pay, I don't remember the name of the company, but they had to pay some damages, which basically amounts to sharing profits, really. With the inventor, with somebody that they had used some technology in inventing their 3DS gaming technology. Somebody had already patented some part or all of that, and Nintendo ended up getting sued, and then they had to pay some pretty hefty damages to that company. Microsoft and Google had a patent battle over something having to do with the Xbox. I'll be honest with you, I get a little lost when we get into intellectual property because my eyes glaze over when we start talking about coding and what inventions and things like that, and technical things. I just have trouble. I wouldn't be able to describe to you in good detail what the Microsoft-Google dispute was over on the Xbox. So I have a note that I made that I can't read, so I'll skip that. All right, let's move to copyrights. So copyright is the right granted to a person who has created music, art, any kind of writing, be it literature or reporting or poetry, anything like that. It is granted to the author or the creator of the literary or artistic productions. So this should make sense to you. You know what copyrights are. I write a book. It can't be used without my permission. We hear this all the time. This image is copyrighted and may not be used without express written consent, so on and so forth. You hear that on sports broadcasts a lot. A television broadcast is copyrighted. You couldn't rebroadcast that on your own channel as your own without permission. This right is granted automatically. You do not ever have to register copyrights. There is no such thing as copyright registration. So remember, patents always registered. Trademarks could be registered but don't have to be. Copyrights are never registered. And that's because in a copyright infringement case, all you got to do is prove that the work was yours originally and that somebody used it without permission. They don't last forever, which sometimes seems a little, to me, a little unfair. If I wrote a book, then I would want copyright protection on my words forever. But protection for copyrights only lasts for the life of the author plus 70 years. So after that, it could start being reproduced by other people without permission. If the copyright is owned by a publishing company, then you don't have to know this, but I'm just giving you an example. If the copyright is owned by a publishing company, which means like a book publisher or a music recording company, then the copyrights would expire either 95 years from the date that they're published or 120 years from creation, whichever comes first. So the point just being that copyrights, unlike patents or trademarks, don't last forever. Let me back up on that because I'm not sure what I told you was exactly accurate. Patents you have to re-register your patents. You may get a patent, but it's only for a certain number of years. And then you've got to keep going on and re-upping it. If you don't renew your patent, then it could expire and then anybody could use it without permission. I think a trademark could be protected for as long as it's in use. It doesn't expire like a copyright does. But if a company goes out of business or abandons a trademark or doesn't use it anymore for a period of time, let's just say 100 years, then, and that company's not even in business anymore, they're not really infringing on a trademark that is A, not in use, and B, there's nobody even sue me for it because the owner of the trademark or the person who enjoys the rights of protection doesn't exist anymore. So I think those could expire as well. So my statement that copyrights expire but patents and trademarks don't is not entirely true. Trademarks and patents don't expire in a certain number of years set down in the law like copyrights do. That'd be the better way to say that. So what are you protected against if you have a copyright? You're protected against reproduction of the work, just straight up somebody copying. You paint a painting, somebody makes prints of your painting and sells them. That's straight up reproduction of your work. Development of derivative works. So they take your work, let's say you wrote a children's book about Peter Rabbit, and somebody else writes other children's books with the character Peter Rabbit doing some of the things that Peter Rabbit does in your books, but it's not word for word copying from your book, right? So that's not a reproduction, but that is development of work that is derivative from your Peter Rabbit books. That's covered as well. Distribution of the work. You might create a song and you record a song and other people can't sell that. They may not be reproducing it, but they can't distribute it either. And then public display of work. If you paint a painting and I want to make a mural out of it and put it on the side of the CCT building here, I can't do that without permission. That also feels a little bit like reproduction, public display does, but it's protected. Protected expression extends to literary works, musical works, dramatic works, plays, pantomimes, choreographic works. So like the choreography of a dance routine. The actual choreography, what the moves are and the sequence of the moves is copyrightable. So I can't go out and have my dance company perform a dance using the exact choreography or derivative choreography from another dance routine without permission. So again, I hope your mind is going to the way I'm hoping to teach you to think about these things. Who in the world decides if I copied a dance routine or not? If we get into a dispute about that, and you think your dance routine was copied, your fate is in the hands of who? The jury. The jury or the judge. You might have a trial without a jury, but it's up to the courts to decide whether or not they copied it enough to have violated your copyright. Carlos?
What about these are parodies? Wouldn't it be derivative of the source, even if it's copyrighted?
So, okay, that's a great question. He was asking about parodies. And you beat me to it, that's an exception. So I'm going to give it that in a second. But I like the way you're thinking. Absolutely. Because there are, as I hope you've also learned in everything we've talked about in the law, there's always a damn exception, right? There are no absolutes really in anything that we've talked about in here. So let me finish. I think I was just going through a list of things that are protected. Pictorial, graphic, sculptural works, so photographs are protected. Sculpture is protected. Films, other audiovisual works are protected. Sound recordings, architectural works, computer software, certain sequences of notes, of musical notes can be copyrighted. And you see a lot of disputes about, well, this artist took this from my song. I invented this, or this certain combination of notes is unique to my composition, and it's been copyrighted. Now, again, where do we draw the line on that? Obviously, you can't copyright one note, right? I mean, it's fair game for anybody to use a B flat in their music composition. Is it fair for somebody to use B flat 2 times in a row? Sure. So where do we draw the line? That's really going to depend on the jury. And I guess you could have some past cases that might give you guidance, but there's never going to be a case on that exact sequence of notes. And so it's just always going to be a case-by-case basis. We do have cases where a certain sequence of notes is copyrightable, but where we draw the line between one note and 20 notes or 30 notes, I don't know where that line is. And there's not going to be a definition in the law that tells you where that line is either. So what are some exceptions to that? Let me back up for a second. What's not copyrightable? Facts are not copyrightable. If I say that, if I write in my book that I'm writing a book about the presidency, and in my book I've written that Joe Biden is president, well, my book is copyrighted. You couldn't go and reproduce my book. You can't reproduce chapters of my book, maybe not even reproduce paragraphs of my book. But you could say in your writing that Joe Biden is president. That's just a fact. You can't own a fact. You can't copyright a fact. You can't copyright something that's not original, like page numbers in a book. That's not copyrightable. Mathematical calculations, a formula. We don't copyright those. Those are truths. So copyright infringement, that's what happens when someone copies your work or makes something that's derivative of your work. What are exceptions to infringement? One is the fair use exception. That is when, for example, if I'm going to write a book review and I want to quote a line or two from a book as an example, or to tell my reader what it is that I'm critiquing, I can do that. I'm not reproducing that content for my own gain, or I'm not passing it off as my own. I'm attributing it to the original author, and I'm using it to critique a music review, a movie review. If I wanted to copy a paragraph from a news article to distribute to y'all, which I do, for our learning purposes, that's fair use exception. I mean, I obviously can't take the article and reproduce it and not say whose it is or pass it off as my own. That's stealing it. But if I'm doing that for y'all for educational purposes, that could fall within the fair use exception. I actually do that a lot. I use articles that are written by people all the time for y'all to use. Again, fair use. What is fair use? case-by-case basis, some of the things that the court would look at are what was the purpose? Was my use related to me making profit? That looks more like not fair use than if it was just for a nonprofit or critical use, as in a review or something. The nature of the copyrighted work, was it, did I borrow information or did I borrow facts? How much of the original is copied? Quantity and quality matters. I might reproduce most of a work. Quantity, that could be violation of fair use. I also could copy a sentence or two, even though that's not high in quantity. The sentence or two that I copied might be the punchline or the main idea or the certain words that article became famous for, or an idea that article was written about. So it's not just, when we're looking at how much was copied, it's not necessarily just quantity, it's quality as well. What exactly was copied? And then they're always going to look at the effect of the use on the market for the copyrighted work. So hopefully, no author of an article is going to come and sue me for copyright infringement for using their article in my classroom, because the effect of my use on the market is none. I'm not affecting that author's profit or his pocketbook. It all comes down to pocketbook, right? I mean, we're not going to go through probably the trouble and cost and expense of litigation over copyright unless somebody's profiting off of us, or they're making us look bad in a way that would affect our future ability to earn or profits. So that's always the calculus in these sort of things. As Mr. Bachame mentioned, though, parody is okay. Parody is not a violation of copyright law. And that is because, in the idea of parody, if we recognize something as parody, we know that we're not trying to pass off that as our own. We're not using it as our own idea, our own expression. We're making fun of it. Now, again, where do we draw the line between parody and not parody? I mean, you're not going to find a definition of that in the law. That's going to be on a case-by-case basis, too. Once you buy something as an authorized owner of something that's copyrighted, so when I go to the bookstore and I buy a book, I had to buy it to be authorized to own it and use it. But once I do, I can resell it without violation of copyright law. Once it becomes ours, that doesn't mean we could take the content and use it as our own or pass it off as our own, but it does mean that we don't need permission to sell it to somebody else once we've purchased it. One other area I want to talk about is trade secrets. Some business processes and information that can't be patented, copyrighted, or trademarked are still protected. Your customer lists. You can't patent, trademark, or copyright your own customer list. We don't publish. The reason they're not copyrighted is we don't publish our customer list. They're private and secret within our own company, hence the name trade secrets. But those are protected as well. Our business plans, our research and development, our pricing information, our marketing techniques, those are all protected. And if those are used without permission, or they're acquired without permission, then those could constitute a theft of trade secrets. So something like Zaxby's sauce is probably a trade secret. I don't think Zaxby's puts out the recipe to their sauce. The secret 11 herbs and spices that Kentucky Fried Chicken uses, that is a trade secret. The Coca-Cola's secret formula is a trade secret. Why aren't companies like Kentucky Fried Chicken and Coca-Cola, why aren't they getting patents for their recipes? Why would you not apply for a patent for your for my soft drink recipe.
That's it, because you have like other competition like Pepsi or.
Yeah, I don't want it to be public. Patents are searchable. There's a public you can search any patent you want, and you can see what the details of that patent are. So those are protected in a way that we would expect that they would, but they fall under trade secrets. There was, I was looking up just some examples for y'all, and the makeup company L'Oreal, they got in, or they were going to do a deal with another company called Olaplex, and they were working through the deal and all this kind of thing, and then it fell apart. Well, while they were working towards the deal, when they were friends, L'Oreal had access to some of Olaplex's recipes or some of their things that would be trade secrets. And L'Oreal used them in their own business after they broke up from their business deal, and they got sued and ended up having to pay damages to Olaplex. And that was constituted theft of trade secrets. So they came about this knowledge unlawfully, basically. So the law does, though, expect the owner or possessor of the trade secret to exercise reasonable care in protecting their trade secrets. You can't be sloppy with it. So some examples of where that's bitten people in the butt are that there was a company meeting on Zoom, but the company meeting was not password protected. Anybody could have gotten in it. And so whatever was discussed there somehow got stolen or used, and the company did not enjoy protection from that trade secret because they weren't careful in protecting it. Putting confidential on an email that you're then going to blast out to 200 employees, that doesn't necessarily confer protection of trade secrets in doing that. So you got to be, if you have a trade secret that is your business list, or a certain way that you price some research and development you're working on, you need to be super careful about how that's disseminated, who gets to see it, so that if somebody did pirate it from you or use it and you were in a lawsuit, you could prove that you were not sloppy with it, that you were careful about protection of that. Okay, pay attention to this. For Thursday, this is what we're going to do. I'm going to put up one case. Has anybody played the game Left, Center, Right? Y'all play that game? Miss Kelly likes that game. So there was a game that was invented that was like that. And the inventors of Left, Center, Right sued this other game. And so the case is going to be what the court's decision was on how that came down. That'll be a good example of how all this stuff works in the real world. The case is kind of long, so I'm going to bear with me. It'll be up at some point today, but I'm going to try to edit it out so that you're not reading just too many pages of case. The other thing we're going to do is that this week's discussion question and our assignment are the same thing. So I am giving you a grade at the end of the semester for answering all the discussion questions. If I get to the end of the semester and you've participated in every discussion, you'll get 100 for the discussion. But this one is its own grade. This is going to be the easiest grade you make all semester. The discussion question is going to be to look up on the internet an example of trademark dilution, trademark infringement, patent infringement, copyright infringement, theft of trade secrets, infringement of trade dress. And you're not writing a report on it. You're not going through any great detail about it. I just want to know who were the parties, what was the dispute about, and then what happened. What was the resolution? And if there are any interesting facts that you want to throw in there, please do that. But don't copy and paste anything from the internet, please. I will not accept that. But I'm not asking you to do a report or do any sort of in-depth thing. I just want you to familiarize yourself with whatever it was that case or dispute was about. And on Thursday, when we finish talking about the LCR case, then everybody is going to take, 60 seconds or so to just tell the class, share with the class what your case was about. Again, not a report, nothing in depth, just be able to tell us, okay, I've found an example of trademark infringement. X company was the plaintiff and they sued because this other person did this and this is what happened. And then we may ask some questions about it, so just be able to discuss it. But again, I don't have time for everybody to spend 5 minutes on your case, so I just want you to, if you will answer that question discussion, and then you will give me that less than 60-second recap when I call on you on Thursday, that's a 100 for the assignment for this week. One other thing that's important. Before you go on the internet sleuthing and trying to find out what you're going to do your thing on, look on the discussion board and make sure nobody else has done it. Now, there's no way for us to absolutely 100% make sure that we weren't doing something at the same time and we posted it after and we didn't know that somebody had already done it. But that'll at least keep us all from doing Louis Vuitton versus Louis Vuitton DAC. I don't want to have 30 of those. If that makes sense. So at least just look on the board. I'm not gonna reject your work because you ended up doing the same thing as somebody else. But do check the board just to make sure that you're not. If you see that somebody's doing it, then don't do that one. Pick something else. There are so many examples out there. You'll be, you can Google stuff and you'll get 10 most interesting cases of trademark infringement. It's not hard to find. Any questions about that assignment or about what we're going to do for Thursday? Okay, I apologize for not having the outline up. I just didn't do my job right this week. So I'll see everybody on Thursday, all discussion on the LCR case and your examples.